This program is brought to you by Emory University.
We have today with us Judge Britt Hammond, who has come to us from the Tombs Judicial Circuit in Georgia. He's been a judge with our state since October of 2004, and before that he spent about 8 years as a Special Assistant Attorney General representing DFACS. He's a graduate of the Cumberland School of Law at Samford University in Alabama. And since becoming a judge, he has done a lot of work in Georgia on a number of committees. He's very active with the Council of Juvenile Court Judges, and at some point in the next year, you will probably see or hear about an implementation guide to new legislation that opens up the deprivation side of our courtrooms, and he is the lead judge on figuring out how all of that is going to work. He's also been very active in a number of ways with the Justice for Children Committee, particularly looking at Title IV-E court orders, foster parents' right to notice and be heard, and of course the Interstate Compact on the placement of children. I'd also like to welcome from out of state Stephen Pennypacker. He is here to us as an expert in Florida and nationally on child welfare issues, and particularly the Interstate Compact on the placement of children. He spent a number of years in private practice, and then he became the managing attorney for the 8th Circuit State Attorney's Office in Florida for a pilot project for representation of their Department of Children and Family Services in dependency matters. So he sort of started an office from the ground up and saw how it worked there. He has served as a general magistrate in the 8th Circuit and handles a number of counties reviewing their dependency dockets. And he also served as a managing attorney for the Department of Children and Family Services. And now he is the ICPC Compact manager or administrator for the state of Florida, as well as special counsel of the Family Safety Program. He serves on some national organizations and national boards, also working with the Interstate Compact. So if there was anything you wanted to know about the Interstate Compact, today is the time and place to ask those questions. One final note, and I'll say this, it'll probably be on the film, is that this is being videotaped, and so if you have questions for the speakers or have conversation with them, please make sure to raise your hand and wait to receive the microphone so that we will be sure to have your voice on the videotape. Thanks so much.
Thanks. Good afternoon. It's a pleasure to be with you. My name is Britt Hammond. I'm a juvenile court judge, and I have been going around the state working, trying to improve Interstate Compact till I met Steve Pennypacker, who's got the solution for us. Anybody who doesn't have strong feelings about the Interstate Compact, please raise your hand. I don't find many people who do. The good news is we're going to hopefully give you some hope today. My part of the presentation is going to deal with kind of the history to where we are now. How do we get to where we are now? Steve is going to talk to us about where we're going, and I have to be honest with you, for the first time in dealing with the Interstate Compact, I am very enthused about what is possible here. So please feel free at any time to ask questions. We don't mind that at any time. Steve and I are going to kind of tag team, and we'll kind of take a break at the end of toward the close of my presentation and before he starts his. Well, what is an Interstate Compact? Just by way of some history and some background, how do we get here? Well, it's an agreement between two or more states, and it's binding as is a contract. It's interpreted using contract law. And it kind of began as a formal process about the same time as the Articles of Confederation. And it was initially used by the states to settle border agreements. So that was kind of its history, that the states were using it, to strike agreements between themselves. As you may be aware, though, our Constitution has a nice little phrase in there that says, no state shall, without the consent of Congress, enter into any compact or agreement. So is it allowed? How do we have these today? And the Supreme Court has answered that for us, that as long as it doesn't affect or diminish the power of the federal government, they consider it to be okay. So that is the case of Virginia versus Tennessee. As long as it doesn't try to make the states have greater power or take away a power of the federal government, it is allowed. And the idea of custody and placement is an issue where that has traditionally been left to the states. Well, what is the impact of that? Now, let me warn you, I do talk fast sometimes. If I get talking too fast, just raise your hand. I'll be glad to slow down. But the compacting states, they're bound to observe the terms, and it takes precedence over state law. They cannot be unilaterally renounced. However, there is a provision, it's Article 9 in the ICPC, that allows for withdrawal by adopting a statute which revokes the old statute, but then it has to stay open for 2 years. That is what is in the ICPC in Georgia law. And of course, Congress and the courts can compel compliance with its provisions. In the state of Georgia, our history is that it was enacted on March 23rd of 1977. Now, it was originally drafted in 1960, and it took 30 years for the states to finally adopt it. All 50 have done so in that time period. But it took quite a bit of time. And of course, what it requires is it mandates certain procedural requirements that must be followed when you place a child across state lines into another state. Why was it adopted? Well, obviously the most obvious reason is that states cannot exercise jurisdiction across their boundaries. And so when you place in a child in another state, how do you have any assurance that what's going on there? Specifically, how do you ensure that the child gets a safe and stable placement and that the child receives supervision and services that are going to be needed or required when the child is placed there? That was the main goals of concern. Another one that we still see today is case dumping. Right? The state has a financial and a moral obligation to its children. And of course, ICPC is intended to be the gatekeeper to make sure that we don't have cases dumped just to get rid of them and close them out. And that it was intended to do that as well. So that sounds pretty good. So that sounds pretty good. The idea behind it, we got the adoption of it, but what is the problem? And it's implementation. The implementation of it has been a major problem. We can all take a little blame. I mean, everybody can take a blame that deals with this system. Let's look at Article 1. Article 1, the stated purpose of the ICPC is to encourage the cooperation between the states. And so to that end, ICPC has 4 main objectives. And the first 3 deal with the approval process. And the 4th deals with jurisdictional arrangements. Now, the approval process is not as problematic as some. If you look at we break that down a little bit more, what we'll see is we're trying to ensure that the states that agree that each child shall receive a suitable placement. All right? How are we going to ensure that? Well, we want to make sure that the receiving state, the state that receives a child, has the opportunity to obtain all the information it can about the circumstances relating to the placement, for safety of the placement and supervision of the placement. At the same time, we want to allow the sending agency to obtain the most complete information it can to ensure that the placement is going to be proper before it's made. So the idea is we're going to promote cooperation by giving everybody involved the most amount of information that we can on the front end. The 4th thing deals with jurisdictional arrangements, and this is a little bit more problematic. I want to read this to you. Appropriate jurisdictional arrangements for the care of children will be promoted. Well, that's pretty vague, and it's been a problem. There's no further clarification of what that is, and we've had difficulty with that. One example of this would be supplementary or border agreements. The states are empowered under the ICPC to actually enter into an agreement with a neighboring state on how we're going to handle these cases, a protocol for that. Georgia doesn't have any. I'm going to feed Steve at this point to talk a little bit about what your experience is with border agreements between the states.
We've tried as a state to have border agreements with Georgia and with Alabama, the states that we exchange children with most frequently. And in going down that road, I asked some of the other compact administrators, do you have border agreements? And sure enough, there are some states that do that. Kansas and Missouri do it because of Kansas City. People go back and forth across that bridge regularly. They sent me their border agreements, they do it. The state of Maryland and the District of Columbia do it because, again, you've got children in D.C. that need to be placed, and frequently they get placed in Maryland. So it is possible to do it, but you've got to get the executive branch on both sides to be able to say, yes, we want to have this happen. We would love to have a border agreement with Georgia, and hopefully one day we will. But it's a difficult process because it's got to be a two-way street.
Yeah, and the experience I've had in just with this, working with this area is there's a lot of just resistance to the entry of border agreement. I'm not exactly sure why, but you probably know some war stories. I've got one from Georgia where it was up in the northwest corner of the state, and this, I think it was a grandfather, wanted the child, and so he actually came and bought a residence or rented a house in Georgia. He was an Alabama resident, and he lived there and established a residence there, and so he could get the child. And when he got the child, then he went back across to his home in Alabama. You see some extreme examples of that. And the idea with the promoting the appropriate jurisdictional arrangements, we haven't really seen a lot of progress there, have we, Steve?
No, sir. And one of the things that would happen with a border agreement, just think through what would happen, is that you would have a caseworker in one state that would then be able to go into another state and conduct that home study. The receiving state would then be bound by it. So the receiving state doesn't usually have the same motivation to get that home study as the sending state does. So if it were possible for the caseworker who is actually wanting to place the child to go across the state line and say, I'll do the home study, and then the other state accept it, then you would probably get these things done more quickly. Licensing, liability, all those issues crop up when you start talking about the ability to do that.
I guess you're president of the national convention. Do you have any states? Are there any states that have these border agreements that you know of?
Well, like I mentioned, we have Missouri and Kansas do. I believe there's a couple of states out west that do, but they are not very many.
So it's not just a problem that's unique to Georgia. The executive branch has resisted that for some reason, and I have had conversations with our state office about it, and they've taken it under consideration, but we were hoping at some point to do that. Well, now, the purposes and policy behind the ICPC find their incorporation right into DFAC's policy. I pull this out just for you to see. It is DFAC's policy that children need these safe protection and services, and that ICPC is the best means to accomplish that. That is right out of the manual. That's the most recent revision that I could find. Let's look at it a little closer. Article 2 of ICPC sets kind of the operational framework for how ICPC works, and it revolves around 4 terms. And really the first 2 of these have not been that big a problem. The second 2 and the interpretation of them has caused us a world of frustration. So let's look at those a little closer. Child. A child means a person who by reason of minority is legally subject to parental guardianship or similar control. We don't really have a problem with that one. Everybody is on board with what a child is. So that one's not really problematic. Receiving state. Once again, not really as problematic, and it means the state. Now, it refers to a state which sent, brought, or caused the child to be sent or brought. But that can also encompass private agencies, okay? If a private agency sends a child in, it can be public or private. But as far as receiving state, it is managed by the state. Now, whoops, I got to go back, Steve. Sorry, I jumped too quick. Sending agency, it has been problematic. I want you to look at this definition because it's very broad. It not only means a party state or an officer or employee or agent thereof, it also means a court. It also means a person, a corporation or a private or charitable agency or other entity. This idea is very, very broad as to what is going to be, when you're going to be under the terms of the compact. For a little bit further into that, once again, you see it does not say sending state. It is not limited to state action. Now, it is broader than that. So it's broad enough to cover virtually any entity which sends, brings, or causes a child to be sent or brought into the other state. Now, if you are found to be bound by it, then you must comply with the requirements of ICPC. You have to go through that. And just to show how problematic this can be, in certain circumstances, parents are considered to be a sending agency. If they want to do an adoption across state lines, in certain circumstances, they are considered to be a sending agency and then required to follow the ICPC. Now, there is this limitations idea in ICPC of when it will not apply. There are exemptions in Article 8. You see that their exemptions are made if it is as a parent, a step-parent, a grandparent, brother or sister, or uncle or aunt, or guardian. If they bring the child into the state and leave the child with one of these recognized relations, then it will not apply. Now, there's obviously going to be some problems with this as well. Why do we exempt certain relatives? Now, remember, the purpose of ICPC was to ensure safety and protection and to ensure that the child gets services. Well, why exempt these? Now, a lot of my colleagues, you know, they feel very strongly about this. You know, and ICPC considers that biological connection alone, standing by itself, to be sufficient protection to ensure the safety of the child. So I have heard of cases where a mother may show up. Maybe the child's in the custody of dad. And dad, all the allegations are against dad. Mom's in another state and she shows up and she wants the child. And I've heard of cases where the case will just be dismissed and given to mom. And you know, to take back across state lines. I hear a lot about that. But what I want to ask you is, we need to look at the underlying assumption there. Is that biological connection alone sufficient to provide protection? Look at this hypothetical. What about a parent in state A who sends a child in state B to be adopted by an adult relative who potentially has had no prior contact with the child or who may have maltreated the child? In Georgia, we have a case, Rakowski versus Gilbert, where the aunt brought the child into Georgia and later wanted to adopt, and she was allowed to without complying with ICPC. How do we know the child was safe in that circumstance? Is that assumption correct or not? I think there might be some problems with that. The biological relationship, the idea that biological relationship alone eliminates the need for it. The other idea here is these guardians. You may notice it said that guardians were exempt, but it didn't provide us any definition of what a guardian is. It's not defined in the compact. So how are the states going to decide what a guardian is? How are they going to decide what it is? It is totally not in there. Now, the Association of ICPC Administrators, they have the power under Article 7, I believe, of ICPC to make up rules and regulations. And they have made one that addresses this issue. And it says, it's right here. Guardian means a public or private agency, organization, or institution which holds a valid and effective permanent appointment from a court of competent jurisdiction. And that appointment is considered permanent if it would endure until the child's age of majority without further court review. But are these regulations binding on the state? Steve, can you tell us a little bit about how that process works with the regulations?
We have just adopted the new ICPC in Florida, and one of our issues in doing that is the delegation of rulemaking authority that takes place in Article 7 in the current ICPC, as Judge Hammond said. Under Article 7, the compact administrators are given the power to create these regulations. Some courts have looked at that and said that's an unconstitutional delegation of rulemaking authority. So while the state may be bound by the articles, because those are adopted by the legislature, because the regulations are adopted by the compact administrators and not by the state legislature, that the court's not bound by that. So as it would apply in this case, if the definition of guardian would prohibit the kind of transfer that Judge Hammond is talking about, a state could say, or a state court could say, we don't consider the regulations binding, so that's not going to help. Yes, ma'am.
Yes, ma'am, in the back.
Yeah. I just need some clarification because I'm a child advocate in Fulton County.
That really, all right, yeah, I'm sorry, let me see if I can repeat that. I think let me make sure I get this right. I think what you're concerned about is you're under the impression that it was just applying between state agencies when they transfer across from one state agency to another. And it is much broader than that. The ICPC does cover, it covers adoptions and other situations where the child is placed across. Now, in just a minute, we're going to come to a slide about placement, and there are some exceptions where if a child's sent to school in another state or if they're in a mental health facility, it will not apply. But to answer your question, does ICPC apply to other than just state agency involved cases? Yes, it does. Steve, you want to add to that?
Yeah, that's correct. I mean, it does apply outside of just a state taking custody of a child, as the judge mentioned, private adoptions, and that's about 25% of the work we do in Florida. It causes us more problems, believe it or not, than all of the state cases combined. Because once you take a child from a parent and they've signed a consent for an adoption, usually that consent either goes to the person that's going to adopt or to an agency or an attorney. Now that placement is being made by someone who wants to argue that they're a guardian, but they don't really have a court order that says they can make that placement. So they need to do an ICPC so that the two state capitals can make sure that that child going from state A to state B is going into a home that state B says is appropriate. So ICPC applies there. It also applies in a placement for residential treatment. So we actually get notification from parents who will place their child into a mental health facility in another state because that state needs to know the child's there so that if something happens, they know who to notify. If the child goes into a mental health facility, they got to be able to contact somebody back if something happens that way. So it is not just kids that are in state custody. Yes, ma'am, you had a question?
The question is, can the courts in the individual party states interpret the terms any way they want to, I mean, in opposition to maybe the regulation?
Some courts have held that. Other states have not held that. And one of the reasons we need a new interstate compact is to address this particular issue. I can tell you in Florida that we've had cases where this has come up and the courts have been able to make a decision in that case without having to rule on whether or not the regulations are binding on the state. They've been able to resolve just on that simple fact pattern. But it is an issue. I mean, it's there. Now, the other side of the coin is the articles delegate that authority to the compact administrators, and if you adopt that law, then you have given that authority to the compact administrator. So the flip side of the coin is, yeah, they are binding on you. One alternative that some states have done is to adopt the regulations and the articles into their administrative code so that you are then bound by it that way. It's not a statute necessarily, but your code that governs your conduct as a state employee.
Well, and obviously the regulation is trying to give us some idea or give us some guidance on this, and we're going to see in just a minute how exactly that scenario playing out in a case. Just to continue the idea on sending agency, though, if the sending agency, once the sending agency sends a child, they retain jurisdiction under Article 5. The state, in this case, if it's the state sending it, then the state retains jurisdiction. There's a case in Georgia, 2003, up in Bartow County, where a child was placed in Georgia from South Carolina. And the issue was who has control over the child. And Judge Tilley ruled that South Carolina did because South Carolina sent the child. And the Court of Appeals said she's correct, that that South Carolina retained control over custody, supervision, care, treatment, and disposition retained with the sending agency state. So that's an important factor, I think, that sometimes gets overlooked in this. Now, the other problematic definition we have is placement. This is kind of a long definition, and this kind of comes back to the question that we had a minute ago. And really, I'm just not going to read the whole thing. You've got it in the packet there, but it has terms in there that are very vague, like family-free or boarding home. But it also says it does not include mental health facilities and then kind of like boarding school placements of children. So it does not include those. But what do those terms mean? I mean, what does family-free and boarding home mean? I mean, you see that we have 50 states with this same regulation, and each one of them can kind of draw their own conclusions because they're not really defined. Well, family-free and boarding home has kind of been interpreted, basically the consensus is that it's free versus paid placements. But now, where does adoption fit in that? I mean, where does it, we're talking about, does it apply to other things? Where does adoption fit into free versus a paid placement? Does it include adoptive placements? And the answer is yes, it does, because there's other language in the compact that requires approval preliminary to a placement for adoption. You ever see any issues related to that, Steve?
Oh, we do. I have a current discussion with the adoption attorneys in Florida as to whether or not the Interstate Compact applies when you have a relative placement for a private adoption. So as you showed, the exception to the ICPC when a relative is placing a parent or a step-parent is placing a child with someone else in the family in that group of relatives, the private adoption attorneys are saying to me they should not have to do an ICPC when that's an adoption. I think they do. We have not yet resolved it, but it's still one of these things that the compact just isn't clear enough in trying to say yes or no.
Right, and it kind of goes back to the first question we had about the breadth of it. And see, because the sending agency definition is so broad, it does cover a lot more than I think most people really believe it does. I mean, my first involvement was, of course, through DFACS, but at that time it never crossed my mind that it was as broad as it is, but it is much broader. Now, placement, let me show you some of the problematic ideas with this placement definition. What about adopted placement by birth parents? This is kind of alluding to what Steve was saying. And the consensus by courts is that it applies to direct adopted placements to non-exempt individuals. So not the ones that it's limited to, the I just mentioned earlier. So if a parent's going to do an adoption across state lines to a non-exempt, everybody seems to agree that that's covered by that requires ICPC. But what about placements with parents across state lines? What about the mom who's from Florida who shows up at the hearing and wants the child? Does it require that? Well, there's this regulation by the Association of Compact Administrators which says that when the court arranges for a placement with a parent in another state, that it does kick in. It does. And this is going to show a little bit of the problem we have with the regulations. There's a famous case out of the Third Circuit Court of Appeals where the federal court says that the compact administrators, they went above their authority when they said it included that. They say, you're wrong. This was to deal with substitute arrangements for parental care, but not when it's the natural parent. And the court side, it's a very interesting case. You might want to read it, but they make a very good argument, and it goes through kind of the history of the ICPC. It has a lot of interesting information in there. But they basically say the compact administrators were wrong. What do you say to that?
Well, if you look at the exact language in the exception, what it says is that a court is not required to do an ICPC and to place a child with the non-custodial or the parent not from whom the child was removed if you don't ask for evidence as to the fitness of that parent, you don't have any evidence that the parent is not fit, and you relinquish jurisdiction. So in Judge Hammond's situation where you shelter a child from mom, dad shows up from another state and says, hey, I want my child, as long as you don't do any kind of background screen on him and you don't have any reason to believe he's not a fit parent and you relinquish jurisdiction, you can give him the child. At least that's what the regulations say in the ICPC. I think that's consistent with McComb versus Wambach. That's the test we apply in our cases. But the issue comes up, what if you get in that situation, the judge says, well, I'm not really too sure about this guy, I've never met him. I don't really know. Nobody's done any background screen on him. I want to do an ICPC. Then somebody goes and does a little criminal history and finds, hey, looks good to us. Now you're stuck with this ICPC. That may take you 5 or 6 months, and the judge is saying, I'm not waiting. Terminate jurisdiction, forget that. Now you've kind of got a problem because now you've asked for an ICPC, and to me, you're not following the regulation exemption as it's stated. So
in my reading and research on this, I was noticing where there seems to be a little friction between the court and the ICPC administrators on this about it was not a very well-reasoned case and stuff. Right. There's some friction going on there. Yes, ma'am.
So what if you have a case where you have joint custody that hasn't been proved to have been deprived?
The question is what happens if you have a joint custody situation, parents in different states, child's removed in the receiving state or the state where the child is. To me, if I'm a judge in that case, I'm going to relinquish jurisdiction right back under UCC-JEA, shelter the child on an emergency basis, and say family law court in the state where they have their custody order has superior jurisdiction. Let them decide. There's already been a finding by that court that this parent is fit. Take your kid and go. Go hash it out in the other state. That's what I would do. And then ICPC, we don't have to get in the middle of that one.
Well, we don't have a lot of case law in Georgia about this, but we do have one on this particular situation, and it involves Florida, where the mother showed up and she showed up at the hearing, she wanted the child's in DFACS custody, and the Court of Appeals said, nope, ICPC applies because you're a non-resident and the state of Georgia has custody of the child. So that's kind of what the law is in Georgia, but there's a lot of friction on that. Is that going to be addressed in the new ICPC?
Yes, sir.
Okay. All right. We're going to get more on that shortly. But that's the law in Georgia. And once again, we don't have law on a lot of areas of this, but we do have it on this one on point. So generally...
Got another question?
I'm sorry. Yes, ma'am.
When we talk about parents...
But you're asking about putative fathers, where do they fit into that? And my answer would be, it would be a matter of proof as whether or not he can establish that he is the biological parent of the child. You have anything different?
This is one of my pet peeves because our law in Florida is not as clear as it should be in our dependency statute. To me, if, in our state, if you're named on the birth certificate, then you have to have acknowledged paternity to be on that birth certificate now. If you're married to the mother, you're the legal father as a matter of law, regardless of who the biological father is. If you've got a court order that says you're the father, one of those three. If you don't have one of those three, you are just what you said, a putative father. You have no rights to that child, I'm sorry. Go establish paternity, come back and we'll talk to you. But just coming in and saying, hey, I'm the daddy, doesn't get you your child unless you've got a court order, birth certificate, or you're married to the mom.
Yeah. Yes, sir.
Yes, sir.
What if he legitimates? He didn't legitimate.
Come back and decide in the best interest of the child at that point.
So the question was, what if he legitimated? Right.
What about how does ICPC apply then?
The same as we've been discussing. Now you've got your parent. Now you've got to talk about whether he's exempt or not, depending on the placement.
So if I understand you, you're saying parent doesn't include a putative father as...
The question is, parent doesn't include a putative father. A putative father is putative. We think he's the dad. He's alleged to be the dad. He has no legal rights. Mom says he's the dad. He may come in and say he's the dad under oath. Until a judge makes that finding, he's not the dad. You could name the putative father. I've never met the woman.
But there are no regulations that specifically interpret parent that way, is that correct?
No, but in our work, we do it. And I can tell you, in our work with Georgia, this state is as strict as they come in establishing paternity. So if we send a home study request up here to say we want to do with grandma, paternal grandma, if we don't have a court order that says they're the dad, a birth certificate says they're the dad, or they're married to mom, you won't do the home study. So we have to establish it. We can't just say putative. It doesn't work. Yes, ma'am.
Oh, I was going to, well,
Yeah, the question was, once he's legitimated, does it still ICPC apply? Yes, it does. But the original question was, what if it's putative? To me, putative fathers have no rights. Once they've legitimized, now you treat them as a parent, then ICPC applies or doesn't, depending on whether the regulation applies or not.
Right, so in that situation where he legitimated, he is now definitely within the limitations. I mean,
Right.
there's no problem there. He would be able to apply it as a limitation for causing or bringing or sent. You know, but yeah, that raises that's interesting, Steve. So how does it work? To come back to this is where we get a lot of grumbling. You know, how does ICPC work? Theoretically, it's supposed to resolve itself within 30 to 60 days, and this is kind of works every time. Works every time. This is why I said you're in for good news. You're in for good news. Don't hang in there with us. This is kind of a breakdown, and this is kind of maybe Georgia specific. And actually, the days that are listed on there, although Steve, you looked at it, it's probably the same way everywhere, pretty much, isn't it?
Oh, yeah.
This is kind of generally how it goes through the process, and I put the days in there, and that actually came out of a guide that was put out by, I think, the Association of ICPC Administrators, a guideline of how long that should take. So the need for it is identified, the court issues the order, they get the packet together, the sending agency sends it up from the local agency to the state. You see about how many days it's supposed to go, then the sending state administrator ensures it's all together, and then it's fully completed, and they send it off to the receiving state. But the problem is, you know, it can play a little tennis in there, right? I mean, this has been my problem with it all along is what happened to it. I've got my caseworker there, and I ask, where are we going with ICPC? Well, it's at the state office, or it's in the other state. I mean, they never know where it is. I mean, it just gets lost. It goes into the black hole, the ICPC black hole. So let's keep following the ICPC ball. Theoretically, the receiving state then receives it, the packet from the sending agency. That's compact administrator within 3 days, gets it, makes sure it's all together, and gets it out to the local agency. Now that might be a state agency, or it might be a private agency. In Florida, they do private. You know, here it's going to come to the local DFACS office. Once again, that's supposed to take 3 days. And then once the local agency receives the request, they're supposed to conduct a home study, get it back to the ICPC administrator in the receiving state within 30 days, 30 to 60 days. Then once the receiving state ICPC administrator gets it, they have the authority to approve it or deny it before it goes out. So both states get this authority. So receiving state can say go or no go. But either way, it's going back over to the sending agency, and once again, that's supposed to be 3 days. Once the sending agency state ICPC administrator gets it, they review the home study, and they get a go or no go authority. And then once again, that is supposed to occur within 3 days and get back down to the local agency for court review. So the whole process is supposed to occur in under 60 days, and it rarely does. It rarely does that. and as you know, the problem is transparency and accountability. We just don't know where it is. We cannot track down who's got it. The blame game gets cranked up. It's everybody's fault, but nobody knows where it is. And I have a world of trouble as a judge. I know I have the ability to contact the judge in the other state, but who is that person? I mean, I don't even know who that is. It's just a very big lack of accountability and transparency on that process. Other problematic areas of implementation are one, and this was came out of a study I conducted with our juvenile court judges, and this is one of the biggest areas they have problems with, the home study. I mean, sometimes you get a very comprehensive home study. Sometimes you get almost nothing. I mean, it's very hard to really evaluate what you're doing with the child because there's no uniformity between the states on what the content of those home studies are. And another one is, of course, delays. You contact the caseworker, you get them into court, and they're like, well, it's at the state office, or it's at the other, it's in the receiving state. They don't know. They can't tell you. They don't know where it is, so the delays. Now, one thing that I have learned is, you saw those timelines. Well, if the packet goes from the local agency up to the state office and it gets rejected for some reason, it goes back and the time starts over. So you can have a little ping pong action going, and the time gets extended out because it's not complete for whatever reason. That also accompanies with the delays in the review and the approval process. I don't know if I still today understand what all goes through that. It's supposed to happen within 3 days, but it seems like it rarely does. There's also delays in completing the home studies abroad, and we have no accountability to know who those are, or who's doing those, how they're being handled. So this is some of the problematic areas that our juvenile court judges have identified in the process. Well, the question then becomes, why comply? Because there's so much frustration with ICPC. This is just I hear comments like, this is just a big mess. Why should I do this? Why I just want to get these kids to a safe place. What's the big reason? Well, the reasons stated in the compact itself are that it's punctual by laws in both the sending state and the receiving state, and a violation is sufficient to revoke authorization to place or care for the children. That's what the stated compliance reasons are. But there are more important reasons, and they deal with the children themselves. If we don't follow the ICPC with the child gets in the other state, they might not get the services they need, including the ability to obtain certain government benefits. Steve, you want to add to this?
Oh, I can tell you if an illegal placement is made, because honestly our judges do it almost every day. And when a child ends up in another state and they're placed there illegal, either without an ICPC or over a denied ICPC, we get the communication back from the other state office. Thanks for sending this child, no services. So if you think we're going to go out and check on that kid, or we're going to give you concurrence to relinquish jurisdiction or terminate supervision, not going to happen. Basically, you're on your own. So if you put that kid in that home and we told you not to, not our problem. And that's not a good thing for children, not a good thing.
If you tell them not to just because the state has not...
Well, she was talking about kind of, I guess, options to ICPC placement where a person kind of takes it upon themselves to meet the requirements, and then the judge allows the person to take the child out. But my question there is, how do they establish a legal custodianship over the child in that situation? I mean, how does that person in the other state get legal custody over that child?
We will move the Georgia case.
Well, so what she's saying is that the judge will just ensure best he or she can the requirements are met, and then modify custody to that third party. I mean, and the problem there is, and listen, I know that happens. I know it happens. But the problem there is, once again, there is no safety valve to ensure that the child is safe. It's just like my hypothetical earlier. How do you ensure, how do we have some assurance that the child is going to receive services? What if it's a special needs child? I don't know, we can make up all kind of hypotheticals. But I think the problem there is that we need to have some assurance that the child is going to receive necessary services, necessary benefits, and protection. You have anything you want to add to that?
Well, my opinion as the compact administrator, your judge is not following the law. When they raise their right hand to swear to uphold the laws of the state of Georgia, they're not doing their job. I'm sorry. I understand the frustration. I'm going to show you ways to deal with that frustration. And I know why judges do that, but they are not following the law, and they are putting kids at risk, and I just can't condone that. I'm sorry.
And listen, some of your questions, like I said, we're getting close to the break, but some of your questions I believe are going to be answered on down the road, because once again, we're bringing a message of hope on the ICPC today. It's coming in the second half. It's coming in the second half. Any other? Yes, ma'am. Well, you're in the right seminar. You're in the right seminar. Yeah, she's talking about she went to a conference earlier, and what they were saying was they were more concerned about how we're going to get around it than actually how we're going to fix it. And of course, listen, the frustrations that you have, they're all over the nation. Just easy to say, they're everywhere. And once again, we've got a message of hope for you, hopefully.
I just wanted to comment. I've had several. I'm going to get the assistance that she needed for this job.
Right. She was
Florida.
Yeah, she was kind of giving us an example of how the ICPC is supposed to work in ensuring that the child gets the services that they need. And you know, the bottom line is, I think we can probably name or entitle our frustration with ICPC in one word, and that'd be delay. I mean, I don't think anybody really legitimately criticized ICPC for its desired objectives to ensure the safety of the children, ensure they get supervision, and they're well cared for, protected. I mean, nobody criticizes that. What we criticize routinely is the amount of time and the lack of transparency and the lack of accountability. And it's like the lady said in the back, you know, we're at an age now where we have advantages that they didn't have in 1960 when this was drafted, and that's going to come up shortly. Well, there is the new ICPC. It's out there, and I just put in a little brief word here for you for specific things, not everything, but some specific things that it tries to do. It has more detailed and precise definitions. It has this provisions for arbitration between the states, not really promote jurisdictional arrangements. Now it's got a mechanism to do it. It creates a national level staff to do that, and it's going to allow the ability to promulgate rules, not just these regulations, but it must be enacted by 35 states before it becomes effective, and currently only 10 have done it. I think the most recent is Florida, is that right?
Florida and Nebraska.
The most recent is Florida. Now, I have a website down there, and you can keep track of this on that link. Actually, I think it says currently, I had it at 8, but it's now 10. So that link will get you to the information to kind of keep track of this issue. I am not aware of any movement on this in Georgia. I have not heard any movement that Georgia is moving toward to adopting the new ICPC yet. So I don't have anything to tell you there. Now, how can you help the process? And like this lady said, I was laughing because I got when I was up at the CASA convention a few months ago, I think one of the ladies was talking about the parable of the unjust judge and how the widow had to keep nagging to get justice. And that is a good way. That bottom line is a good way, that to be persistent. If you consistently ask questions and you stay on it, you get attention. Of course, knowing the process helps you know where it is. Making contact in the other state with the other local agency. This link at the bottom is a very good link. I don't know if you're aware of this. We put this out on one of the websites, one child welfare websites, not too long ago. But that website actually takes you to a link where you get a map of the United States, and it gives you the compact offices, the information.
We can go online and show it.
Let's see. Whoops. Oh, I forgot about this. Look at you squared away.
There it is.
So it comes up here, and what you can do is you got a map of the U.S., and you can go down to Florida, and we can click on that, and it'll come up with the information on the Florida office for you to be able to contact people and find out where your case is. So at least it'll get you started. It might not answer fully who you need to talk to, but at least it will get you started. And in Florida now, I did Florida, they actually have a deputy administrator that's assigned just to Georgia. She just does Georgia cases, and so you have one person you can communicate with. And that's a really good idea. So that link, like I said, will get you this, and you can go to any of the 50 states to get that information. Whoops. All right, Steve, you got to help me get up here. Okay, so making contact, if you can participate in the home study, You might check on that. I know there's some resistance to that, but you might find out these are some ideas of ways you might be able to intervene in the process and help speed it along. This is Georgia's information. This is the Georgia ICPC office information just for you to have and to be able to use. Yes, ma'am.
I'm sorry, I have several questions.
She's asking about when the new ICPC, when it started to be adopted.
Right, when did we get a new ICPC?
2008 is when the newest ICPC began being adopted, and as the judge said, 10 states have adopted it in 2008, 2009 combined. We need 25 more, so it's going to be a couple years at least.
Notified the states that they're supposed to be looking at this?
The American Public Human Services Association, everybody that does ICPC has been intimately aware that this statute is out there. Then they need to go to their state administrators. You got to get somebody in your state legislature to sponsor it. You need to get the support of your executive branch to get it considered by your legislature, and then they've got to adopt it. So,
would that inherently be the Department of Human Resources, or would that be?
I don't know. The question is, who does this in Georgia? I don't know how you get your laws passed in Georgia, where you'd start, but your executive branch is where I'd be going.
Right. The Division of Family and Children's Services, of course, contains the ICPC office. And Mark Washington, who is the assistant commissioner over that, he's actually designated, but James Graves is actually the unit manager of ICPC in a state. And I've had conversations with them, but I don't get the sense that it's on the horizon right now.
Well, why is that?
I don't know that why.
Would it not be more facilitate children better?
Not everyone agrees with the new compact.
Okay, I got it.
Let me raise this point as far as the new compact is. You said some people don't agree. My response to that is, do you want the current one? And the other option is, do you want to be the 36th state that hasn't adopted it when 35 do, and now you're on an island? That's where you could end up.
Solving a problem by.
Well, I was at the CASA conference a few months ago, and they were raising this issue, and my understanding from CASA was they were discouraging that. They were discouraging CASA's doing the home studies for liability issues, I think was the biggest issue that I was having.
CASA programs, but they're not discouraging the judges for asking.
Well, as far as if it goes through the process, if a CASA or some private entity does the home studies, what you're asking, will they be accepted? It's still going to have to go through the receiving state, the sending state, and the court to get approval. So I guess theoretically it could.
Right, that's circumventing. They get, because a CASA is not really a private entity, it's a court-appointed special advocate.
True, and listen, I'm just telling you, I just was at that conference, and what they were telling me, the leadership in that area was saying they were totally discouraging CASAs from being involved in that. But I think theoretically they could. Steve, you see any of that? Y'all do private organizations. Do you use any individuals?
We use our private agencies, but they are by law. In our legislature several years ago, we delegated our foster care licensing services down to them. So they're licensed by the state. And they do it by private entity. Licensed clinical social workers can do them. There are other people that can do them, but they have to be accepted by the ICPC office. So if a CASA did it, if it's somebody who's a licensed clinical social worker or by statute, they're able to do it in that state, then it's a question of whether that state agency is going to accept that home study. What happens with us, being a private state, is sometimes we will get other states that say, well, we're not going to do that because we don't want those people doing our services. And then we say, that's it. That's the only game in town. We will send requests to other states. The state agency will go out, or somebody will send us a home study, and they say, we're not providing the services. We didn't do the home study, so they won't accept it. So it's a two-way street.
Yes, ma'am. Yeah, she was saying that that CASAs around the nation, they have a different stance on that. Some will do it, some won't. And what I understood, and once again, this is not coming from me, this is what I understood at the state CASA convention, was that the trend was they were discouraging that. But I think that certainly looked like to me, and when I've been working on this for a couple of years, and that always like to me an easy way to speed the process up. But then again, there are those liability issues. We're getting close to the break on this. Let me just take one more question. Then we need to take a quick break for you. Yes, ma'am.
Well, and I hate to be a thorn, but
She was asking about what are the legal remedies, and Doris says she's all over it. She's going to get a writ of mandamus or contempt or compel. Yeah, I mean, I don't know. There's a remedy stated, and I've read the whole ICPC, and is there a relief stated? I don't see it. But it would have to be something like mandamus or something, along those lines, because I don't see a legal remedy. Let us take a little quick break here before Steve starts. And listen, don't hang with us. We got a message of hope, I promise you. Wait till you see what he's got to say.
The preceding program is copyrighted by Emory University.